This is TWiT.
Here's some good news. The music industry, actually, was it music or was it filmmakers? I think it was actually the Hollywood, filed lawsuit against Reddit saying, you got to give us the IP addresses of people who talk about piracy on Reddit. In fact, I probably should enlist our official attorney here on this one. The company attempted to block it. They said, well, no, we don't want to give you that. And courts have surprisingly ruled in favor of Reddit, and they do not have to hand over these IP addresses. This is one of a number of piracy lawsuits against internet service providers on behalf of independent film companies.
I suspect I haven't digested this decision yet, although I need to. I think these are DMCA subpoenas. And I think the open question was, although I'm not entirely positive, it's possible that these shifted in some way. But the DMCA has a subpoena mechanism. And one of the things that has been happening is that subpoena mechanism seems to have been unlimited by any First Amendment concerns for the right to anonymous speech. It operates on its own orbit and isn't subject to the same type of review that other forms of subpoena authority would have, with huge damage to what happens to anonymous speech if a 512 subpoena can all of a sudden unmask people who are having discourse like on Reddit. And so Reddit, to its credit, has been fighting back about these unlimited subpoenas and saying, no, the First Amendment has to actually come into the picture somewhere.
The lawyers are not going to stop. They say they're going to continue. This is the third time around. The film companies, including, I'm reading from Torrent Freak, including Voltage Holdings and Scream Media Ventures, wanted to use the pro-piracy comments made by 6 Redditors to show that they didn't take the ISP. Are they talking about Reddit or their ISPs? I guess they're ISPs, because that's why they want the IP addresses, not the names. That their ISPs didn't take proper action against repeat infringers, or that lax enforcement acted as a draw. So they weren't asking. In fact, they thought they might get away with this one because they said, we don't want the names, Your Honor. We're not looking to infringe on these people's privacy. We just want their IP address so that we can then contact their ISPs and say, get these people. The judge, thank goodness, the magistrate, Judge Thomas Hickson of the California Federal Court, denied the motion to compel. So that's now the third time, 3 strikes, I wish they were out, they're not, that these movie companies have been thwarted in their attempt to go after the ISPs by getting people who mention it on Reddit. And of course, the judge said, no, you have a First Amendment right.
Yeah, I hope that holds up, and credit to Reddit for pursuing it. I mean, I'm working on a paper right now about the First Amendment problems with the DMCA, because it basically, I think, has a large prior restraint problem where the accusations of piracy can cause speakers and speech to be disappeared, even though there's never been any adjudication for whether that speech is truly wrongful or not. And the First Amendment really shouldn't support that sort of thing. So if that's what an aspect of copyright law is allowing, then copyright law has a First Amendment problem, and the two have to play together.
SCOTUS is going to be very, you were mentioning this before the show, busy. Their docket this year had a lot of, not just First Amendment stories, but social media
a lot of
cases.
Internet things.
Yeah.
Interesting times.
So we're going to, they've already heard oral arguments for all of these, have they? Or
no, it's coming up. The NetChoice CCIA cases, which
that's the big one. Yes?
It is. Well, it's certainly a big one. Maybe it is the biggest one because it's also a double case.
Florida and Texas.
Florida and Texas. So Texas wanted to impose regulation that would force platforms to moderate in certain ways, and Florida had regulation that would force platforms to moderate in certain ways. The platforms largely won at the appeals court. Well, everybody won at the platforms all went at the district court, let me take that back. Everything's weird in Texas. But basically, the 11th Circuit mostly gave a win to the platforms to say, back off state, you don't get to do this, although it didn't enjoin all of the provisions. And in the 5th Circuit, the Texas law, the 5th Circuit is a very weird circuit that basically just makes up law however it wants to, and without being pejorative, in a very MAGA acceptable way. And they basically they produced a decision that really sort of trashed a lot of First Amendment precedent and logic.
Both these cases really come down to the fact that Twitter banned President Trump on January 7th. And they, right? Am I wrong? That they really want to have the state's attorneys general have the right to tell social media you cannot or you must ban this person or this kind of content.
I don't know if Trump is necessarily the instigating point for all of it, but
they sure didn't like it.
Well, they sure didn't like it, but Trump wasn't the only person kicked off of social media. And the laws are framed a little differently. Like the ones in Florida is, I think, focused more on, you can't disqualify journalism and what it counts as a journalist. And they're each framed somewhat differently, but the effect is the same. The states basically want to be able to tell the platforms what they must or must not platform or deplatform, and that's got a big First Amendment problem. But the issue at the courts is
telling a private business who they can do business with.
The question is whether the platform. So there is.
It doesn't even seem like a speech issue.
No, it is definitely a speech issue because. So there's an old case called Miami Herald versus Tornillo, and that case, the Supreme Court said that the government could not force a newspaper to run an op-ed it did not want to run. Like you could not have fairness doctrine type things, particularly with something like newspapers where government doesn't get to regulate at all. And the question is essentially boils down to whether that is the analogy that applies to a platform or not. And a lot of the states and some of the other people who want to be able to force the platforms to moderate the way they want to, mostly because they've gotten deplatformed and they don't like that, want to say, no, I can't even remember because it's such a bad term, but the idea, you have to take all comers, your common carriers, that's the term they want to
We know
use.
They're not common carriers.
They should not be. That it's absurd, and that's not the way.
The phone company is a common carrier. The phone company can't be told who to has you can't have a phone.
Right.
You're too liberal. You can't have a phone. You can't have a phone.
The indicia that applies to an actual common carrier does not apply to a private platform.
Are they publishers though? That's the question. Are they like a newspaper? Are they publishers?
Well, the idea is that they have the same sort of First Amendment rights and editorial discretion that
as a publisher.
I mean, I really hate the term publisher. I don't use it in my advocacy because it tends to confuse people.
Right.
But essentially, that exercise of their own editorial and associative discretion is something that the First Amendment should protect. If it doesn't protect it, then Texas and Florida can order anybody around, although then there may be Commerce Clause and Section 230 issues.
Where do these laws stand right now? In both cases, they've been suspended temporarily by the lower courts.
There are provisions in the Florida one that have not technically been enjoined, but I don't know if anyone's enforcing it, but it's largely enjoined. Okay. And in Texas, it's technically enjoined, but not via the same mechanism. I think it's basically a stay.
But neither state has done anything to...
They can't yet.
Okay.
But as soon as the Supreme Court rules, we'll be off to the races.
And those hearings, oral arguments will be...
So that one is February 26th.
Okay. Soon. A couple of weeks.
Yeah. Imminently, and then and a whole bunch of amicus briefs have come in recently.
Have you filed one for?
I have. So my client in the cases for the net choice cases is the Copia Institute, which is Mike Masnick at TechDirt. It is Chris Riley, who is an individual Mastodon administrator, because we wanted to point out how expressive the editorial choices are, because that is a single human being that in theory Texas and Florida and Utah and California could all boss around.
I'm another one. I run my own Mastodon.
Yes.
I moderate it solely on my decisions. I do not want to be told what I...
Exactly.
Oh, you can't block that person.
So we bring an individual to bear to really illustrate what editorial discretion looks like and why it needs to be protected.
This is one problem, because a lot of the legislators act as if it's big tech only, that's Section 230, and a separate kind of idea,
No.
but it affects me too.
It does.
It affects small people
Yeah.
too, and it's important that they
Arguably,
understand that.
Arguably, these two laws from Texas and Florida attempt to only reach big, but it is not quite clear that they only reach big, and the principle would essentially allow them to reach small.
Right.
So we did that, and the third client on it, actually for the net choice cases, is Blue Sky itself. Because
Okay.
one of the things we're pointing out is that this fixation on everything is big tech and it's just Twitter, Facebook, Google, etc., is wrong, and that there's an entire ecosystem that needs to be protected, and that there's other avenues for getting speakers and speech online. So a lot of the policy thing that was sort of driving the sense of, oh, we must do something, is a myth, and it shouldn't be suborned.
Anything else we should be watching on the
Then
Supreme
in
Court
March,
docket this year?
In March is the case Murphy versus Biden, and this is one where everybody got, well, let me not be that colloquial, but many people got mad at revelations that the members of the Biden administration and a variety of executive branch agencies were having conversations with the platforms, and the results of those conversations seems to have affected moderation policy. So
in this case, Murphy is Governor Murphy of...
No, Murphy is the Surgeon General.
Oh, the Surgeon.
Yeah,
okay.
This was originally Missouri versus Biden, but now that it's at the Supreme Court, the caption has changed.
Okay.
And
so it's the Missouri Surgeon General?
No, U.S. Surgeon General.
U.S. Surgeon General.
So basically, a number.
They were trying to have conversations about COVID.
So the plaintiffs in this case are a number of people, largely anti-vaxxers, who got deplatformed, plus the states of Louisiana and the state of Missouri. And they sued the Biden administration under the theory that the Biden administration was the state actor that caused the censorship of their deplatforming. And this was at the injunction stage, and the district court came out with an injunction that the Fifth Circuit narrowed slightly, but still left largely intact, which basically enjoined federal agencies and made it impossible for them to talk to platforms under this theory that any deplatforming happened was not attenuated at all. It was all at their direction, which is not supported by the facts, not supported by the record. But the big problem is now you have an injunction where the federal agencies cannot talk to the platforms, which means that the platforms cannot talk to the federal agencies. So I wrote an amicus brief in this case. This was just the Copia Institute one, but pointing out that, again, the platforms have their own First Amendment rights. They have their First Amendment rights to moderate how they see fit. And if they want to come up with a policy that deals with, vaccine information, maybe it makes sense to talk to the administration agency tasked with coming up with, with expertise in vaccines. And the other thing is there's the First Amendment right to petition. It's in the First Amendment. You have the right to petition the government, which basically means you have the right to talk to your government, and this injunction interferes with that. So we wrote
It's interesting that it's going in that direction because, of course, the proponents of this are concerned more that the government's going to tell social media what to do.
Well, that's what they're very concerned about. And if it actually did happen where the federal government said, you moderate it this way or else, if it's really pressing the platform's hands like that, then there actually is a constitutional problem. But that's not what the record supports. And even if it did, this is not the remedy for it, because this remedy cuts off all future conversations. And
well, for instance, one of the conversations could be, this is a known terrorist group that's posting content on Twitter, and they're recruiting for terrorism. We're not telling you to take them down, but you should know this.
Well, that
would be appropriate, right? You should know this.
It hasn't just cut off Surgeon General, it's also cut off CISA, so they can't talk about
Security.
cyber threats.
Yep.
They don't like anybody talking about election disinformation.
It's reasonable, though, to say the government shouldn't be allowed to say, take this guy down, but there should be informational. And
the government can't force it. They can't say.
But it's an informational conversation to say, look, this guy's disseminating a malware on your platform. You might want to do something about it.
What the plaintiffs are alleging is that the government did say things along those lines, and they think that's too heavy-handed.
Well, it's true. If a federal government says, we think it would be advisable for you to do something, that's got some weight behind it. There is a question of is there enough weight? Because I think the record does not show that there's enough weight that there was actually state action here. I think
the platforms could say no.
I think you want the platforms to have information.
You want them to have
You
information.
want this flow of information.
Yeah, you don't
want the government to tell them what to do, but you do want this flow of information.
Right. So the government, there's an issue of fact, although I think the record really doesn't get far enough to say whether the government said, you take this down or else.
Does SCOTUS care about that?
I don't understand this court very well, so it's a little unclear. But we ended up filing a brief in support of neither the government nor the plaintiffs, basically pointing out. But the platforms, the problem with this case right now is it isn't really a question of whether there was state action and whether the people who got deplatformed truly got deplatformed because the state forced the platforms to do that. It kind of is irrelevant because the injunction basically said, going forward, all these federal agencies, you're enjoined, you don't get to talk to the platforms. Right. And the functional effect of this non-narrow and incredibly broad injunction is a whole bunch of agencies can't talk to the platforms, which means that the platforms can't talk to the government agencies, their own government, their own agencies who have expertise in matters that would help them make...
You should be able to ask.
You should be able to ask.
Is this guy a terrorist? What do you know?
So we made an argument that basically, like, whatever you think happened probably didn't happen here, but this is not how you fix it.
Right. There should be some flow of information, but maybe there should be a bright line where you can't cross, where the government says, yeah, take this guy
We probably have one. I'm not sure the plaintiffs have made out the case. There's another problem.
I'm sure Twitter always has the right to say, no, we're not going to do that.
As long as Twitter has the right to say no, there's no constitutional injury. The other problem with this is, what is Missouri and Louisiana doing bringing this lawsuit?
Yeah, what's their standing?
Yeah, and the fact that the Fifth Circuit found that Louisiana and Missouri had their own First Amendment rights.
That's a separate one.
This is not good. And I spent this week reading a lot of really depressing amicus briefs on the side of the plaintiffs here.
Hey, thank you for watching this little snippet from our big show, the News Roundtable, This Week in Tech. I'm Leo Laporte. Each week we cover the week's tech news, in-depth analysis, but it's also fun and engaging. You'll find it at twit.tv along with all of our shows. And if you want more, just hit the subscribe button, and we'll be sure to bring you a lot more great content. Thanks for listening.